We're dealing with the specific bills we have for the full committee hearing in at this time. So we're going to, if you're here on House Bill 129, I'll have to ask if you will please remain outside till we complete the regular committee meeting. We have a quorum, so we'll begin business. The first matter we will call will be the bill Senator Kennedy, Senate Bill 128. Senator Kennedy, if you're here, we're going to look at LC 29-63-51-ER. Thank you, Senator. Glad to have you here.
Thank you, Mr. Chairman. Which microphone should I use?
I'll get your microphone. Excuse me.
Okay.
There we are, a little better.
Thank you, Mr. Chairman. I appreciate.
Who's that fine-looking gentleman with you?
Well, it's just a fellow I found in the hallway that said he knew something about this bill, and by way of overview, I have to say that I didn't expect or anticipate that just some annual revisions to the corporate code would create this kind of interest that we see. But nonetheless, I'm glad to see there's an interest in
marching around all morning too outside.
But thank you for your time, sir. I thank the committee for their time, and I appreciate you taking this perhaps out of order so I can get back on the Senate floor. This is Senate Bill 128. I'm going to speak just briefly and then turn it over to Mr. Wanamaker. This bill basically revises provisions to the Georgia Business Corporation Code concerning officers and directors. It provides some changes and provisions consistent with Chapter 8 of the Model Business Corporation Act. Specifically, there's some revisions relative to the number of directors and terms for directors, actions of the board of directors without meetings and things of that nature. These revisions are the product of the Georgia Bar Association's corporate code section and the annual revisions so that A, will be current, and B, it'll also provide certain tracking with the Model Act. These are recommended by the State Bar, and I'm pleased to carry them, and at this point would perhaps turn it over to Mr. Wanamaker maybe to make any additional opening remarks he might want to, and then we'll be glad to answer any questions. Thank you.
Glad to have you with us.
Great. Thank you, I'm Bruce Wanamaker. I am former chair of the Business Law section of the Bar, and I've been the current chair of the Corporate Code Committee, and I have been since 2006. This legislation was proposed by the State Bar. It amends our corporate code. It's generally designed to simplify and modernize our code and for conforming our statutory language to the current text of the ABA's Model Business Corporation Act, which has served as a basis for our corporate statutes since the late 1960s. The idea is that this will preserve our 40-year-old plus tradition here in Georgia of maintaining a modern, flexible, and balanced corporate code that compares very favorably with the general corporation law of the state of Delaware and the laws of other leading corporate domiciles. Our agenda is generally driven by the objectives of ensuring our corporate laws are responsive to the changing needs of business and evolving market conditions, and that they experience an orderly and coherent growth. We strive to balance the need for managerial and transactional efficiency with appropriate safeguards and protections for shareholders and investors. Ultimately, we want to encourage Georgia-based businesses to stay home and incorporate under Georgia law so that any disputes regarding their internal affairs are litigated and resolved here in Georgia courts under Georgia law. This specific bill makes technical changes to 10 sections of Article 8, which governs directors and officers. The vast majority of the changes involve modernizing language, formatting consistent with the Model Act, and changes of that nature. We did add a new provision, which is in Section 870. It concerns the allocation of business opportunities. It's a provision that's designed to make the corporate code consistent with our Limited Liability Act, the Limited Partnership Act, as well as the laws of Delaware and of the Model Business Corporation Act as well. In general, it addresses some uncertainty about the corporate opportunities, the business opportunities that belong to a corporation, and essentially provides mechanisms where It can be established up front what opportunities or classes of opportunities actually belong to and are property of the corporation and cannot be exploited by a director or officer while they're a director or officer, after they're a director or officer. So it kind of allows people to set a roadmap up front, have an understanding up front. It also provides for a mechanism, a safe harbor, that is based on the safe harbor that's been in the code for years for conflicting interest transactions, where if an officer or director is concerned about whether an opportunity they'd like to pursue belongs to the corporation and they'd open themselves up to claims, they can go to the corporation, the independent directors or qualified shareholders, and essentially get permission to pursue a particular opportunity or be told that no, it belongs to the corporation. So with that, happy to answer any questions.
Thank you. Let me ask one question, just to clarity on this point. You mentioned it's a bill sponsored by the State Bar. It's gone through the Board of Governors for review and approval by the Board of Governors prior to being submitted to the legislature.
That is correct, sir. It went through the Advisory Committee on Legislation. It went to the full Board of Governors at the mid-year meeting, and they approved it.
Thank you. Questions of committee members? Mighty quiet bunch of lawyers here. Started messing with the corporate code here. I want to. You and I had a long discussion, which I appreciate your taking the time to go through that part with me. That is the issue about the fiduciary responsibility that is owed by a certain officer, but at times also a director. And the question I had there is, we don't want to leave open what may be a potential mischief in the way that officers are able to say, well, I'm going to take what may be a business opportunity that really does belong to the corporation, secretly do something to keep that from being brought to their employer, and thereby make profits use of that opportunity separately. So you're saying this bill does not give that opening to someone in that role?
That's correct, and in fact it can help prevent the mischief by allowing the corporation to adopt a policy or provision in their charter stating very clearly up front that these particular opportunities belong to the corporation. They can't be pursued by an officer before or after their tenure as an officer, and it can be included in their agreements and things as well. So I think it helps actually deal with that problem. Thank
you so much. Glad to have you here today.
Thank you very much.
Do we have anyone else who wishes to address the committee on Senate Bill 128? If there are none, then we'll close all further public input, and the bill is now in the breast of the committee. Do we have any discussion among members of the committee? If there be no discussion, the chair will call for entertainment of motion. Do we have a motion? Motion is due pass. Is there a second to the motion? It's been seconded. Is there any discussion on the motion? Any amendments? Discussion on the motion. We have Mr. Weldon.
Mr. Chairman. I'm sorry, yes, sir.
Did you push? Yes, sir.
Yes,
Go ahead.
Mr. Chairman, I'm not sure if this is is intended to be in here on line 21. After the words that are underlined, and they say the words are "and subject to oversight," comma, then there's "of," then there's a comma following "of," then there's a line over that comma. Is that intended to be there to indicate that comma be removed?
Yes.
Okay.
That is a removal.
Mm-hmm.
It's a very short line, but that's what it is.
Okay. Thank you.
Correct, Ms. Travis?
That is correct, sir.
Thank you.
Thank you.
Yes, sir. Mr. Kelly?
I wanted to make an amendment at the appropriate time, Mr. Chairman.
All right. Is this one you're having published?
Yes, sir. I think they're distributing them right now.
All right.
And Mr. Chairman, I'm going to need a little bit of assistance from Ms. Travis on the proper merging of two pieces of legislation. House Bill 295 was a bill that made it out of the Judiciary Committee and just got caught up and didn't get quite finished in time to cross over.
Right.
It was at the request of the Secretary of State's office, and really was just adding foreign limited liability company and limited liability company into several of their code sections on their responsibilities. I think everyone's getting that handed here, but again, we just want to attach the substitute that this committee prepared and passed out, that's before you, LC 362757 ERS, onto this legislation.
Don't mean to scare you, Senator. It was a bill that passed out of this committee, did not have the chance to get considered on the floor. We're looking to keep that issue alive, and we'll have it as an attachment to a Senate bill for an amendment. It was appropriate legislation, and we'll at least entertain that as a. Everyone have a copy of the proposed Kelly amendment. Do we have everybody have any question of the Kelly amendment? Anyone would speak to the amendment? Would you speak to the amendment for us, Mr. Kelly, again?
Yes, sir, Mr. Chairman. Again, this was at the request of the Secretary of State, and currently they do not have foreign limited liability company or limited liability company in several relevant code sections, and so they were adding in that just really into just several of their overarching sections there, and that's really as we walk through the bill, that's what they're doing. They're adding in the limited liability companies.
So you have that offered as amendment.
Yes, sir.
And do we have a second to the amendment? Discussion on the amendment. Ms. Travis, you have any questions regarding this being placed as amendment as far as the protocol of it?
And I apologize for the late notice on that, Mr. Chairman.
I'm following you, sir. Doesn't look like any conflict with the legislature divided in Representative Kelly's bill.
They're both under Title 14.
Right, we know what I'll have to say about that.
All right.
I think they were.
Any question you have, Senator, as to the proposal?
No, Mr. Chairman, I appreciate the earlier explanation, and I think from my sources that know more about this than I do that the amendment is fine.
Thank you. We have a motion that's been seconded to have the Kelly amendment adopted. Any further discussion on the motion? The chair will call for the question on the motion first. All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. Motion carried. We're back to the main question. Any further amendments? No further amendments. The chair will entertain the motion, which is a motion do pass as the bill has been amended and be a committee substitute for the Senate Bill 128. All in favor of that motion signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you so much, Senator.
Yes, sir. Thank you, Mr. Chairman. I really appreciate your time and the committee's time on this in consideration.
Glad
Thank
to do
you.
it.
The State Bar offers its thanks as well.
Very good. Good to see you, Mr. Wanamaker.
Yes, thank you, Chairman. Appreciate it.
5 years before we probably see you again, right? All right, Dewey, I think you had, I know Mr. Jacobs. Oh, Mr. Kennedy. Who will be your house sponsor on the bill? Who you want to present it? Me? Okay, I'll do it.
Please.
Look at the State Bar. State Bar. All right, I'll present on the floor.
Thank you, Mr. Chairman.
All right. Mr. Jacobs, you had some need to be somewhere else shortly, so I'm going to allow you to bring up your bill. Actually, it's the bill number 9065, is it? Correct. And that is Senator Stone. Please come forward, Senator Stone. And
good afternoon, Mr. Chairman.
We're going to now consider Senate Bill 65, which is LC. Get the door closed, baby, please. A lot of noise bleeding in. LC 296614 ERS. Let's hold the door shut if you could for me there, officer. All right, sir. We're happy to have you with us today, as always.
Glad to be here, Mr. Chairman. This bill, my part of it is at the very end. It deals with raising the wild card exemption in bankruptcy cases. This implements a study committee recommendation made a few years ago. The wild card exemption has not been adjusted.
Might
for
pull that
nearly
mic over a
30
little bit. The other one, I'm sorry, I know where that one comes from. That's for the press.
Yeah.
That black one on your left is the one we're using. That's it.
Great.
There we are. Thank you.
The wild card exemption has not been adjusted in 30 years. It basically allows people who don't have a home or a homestead to claim to use a portion of their homestead exemption to claim other assets. And it's called wild card because it's not specified by kind or type, like a vehicle or furniture.
Does it usually address vehicles as a major
It could be added to the vehicle exemption now is $5,000. If you wanted to put all of the wild card exemption on the vehicle, you could exempt a more valuable vehicle, but it would not have to be used in that way. But generally, it's intended to allow persons who don't own a home with equity to have some benefit from Georgia's homestead exemption.
As you know, there's been apparently an amendment placed on the bill in subcommittee. Tell me where is the section, if you have a copy of the bill, if you need one, I can get it for you, that you're speaking of as far as your initial.
I'm looking at a different version. I believe it's 296602 ERS.
We'll get you the current. There's the one that came out of committee.
Thank you.
I hope I'm right.
Page
Travis,
47. It is part, section 6-1.
And what line number would that be, please?
Line numbers 1555 through 1560.
So you're at the very end.
Right.
Okay. And so we turn over to line page 14. We're 47. Excuse me. Yeah, 47.
At the top of the page.
All right. And so the amounts that we're changing from is on line 1558 from 600 to 1200, plus the unused amount exemption not to exceed, changing 5,000 to 10,000.
That's correct. The current homestead exemption that you're allowed to use a portion of is now 22,500.
Have you received any objections to the modification?
I have not received any objections since this passed the Senate.
Thank you. Now, with that said, I know, Mr. Jacobs, you want to talk to what occurred in the subcommittee's consideration.
Certainly. Certainly, Mr. Chairman.
I think I got you.
Is it? There we go. Certainly, Mr. Chairman. The bill, as it came into subcommittee, of course, only contained the update to the bankruptcy wildcard exemption. We have amended the bill to include the text of House Bill 197, which did pass the House unanimously, I believe. And that is the Uniform Laws rewrite that updates the Uniform Foreign Country Money Judgments Recognition Act, Article 1 of the Uniform Commercial Code, and the Uniform Voidable Transactions Act to make Georgia's versions of those three existing uniform laws consistent with the most current versions promulgated by the Uniform Law Commission. One other thing that was added to the bill, which I'm not putting my finger on immediately, but I can tell you what it does, is the Uniform Law Commission some time ago recommended a repeal of Article 6 of the UCC dealing with bulk transfers because of the way that that conflicts with the secured transactions portions of the UCC. Every state except for Georgia has adopted that repeal at this point. We are the only state that has not repealed Article 6 of the UCC. That came to my attention after House Bill 197 had passed the House, and so I have added that in this version of the bill. But it's all various provisions of uniform laws that relate to the debtor-creditor area of practice.
Right.
Page 35 is where the Article 6 repeal is located.
So that's on lines 157 through 162, which is under Article 6, correct?
Yeah, 1160 through 1162. That's correct.
And Senator Stone, any questions in your mind with regards to the proposals?
I don't have any strenuous objection to any of these changes. They appear to be bringing Georgia's law in line with the uniform statutes in their areas. And bulk sale law in the commercial code has not been used in years, so I would not object to the repeal of that. These are all areas that I'm generally familiar with, and they appear to be in order.
Thank you, sir. Ms. Travis, you have any questions about it? No, sir. All right. Members of the committee, number 14, is Ms. Weldon.
Thank you, Mr. Chairman, and to the authors of the bill. I think the Bulk Sales Act was enacted before we had Article 9, where you had, for example, lumber yards, and when they would go out of business, and they would have obtained lumber from other sources, they'd go out of business, they would sell their inventory, and it wasn't a good way to secure an interest in that inventory. And the Bulk Sales Act was predating Article 9, which provides for a good way to attach and secure and perfect an interest in the inventory. The Bulk Sales Act made you had to file an affidavit, give notice to creditors and that type of thing, and that's just since Article 9 has been enacted in Georgia and been working for a long time. I think that's the whole reason to get rid of the Bulk Sales Act. Is that right? Or that's one of the big reasons.
Right.
That is correct, and as I mentioned before, Georgia is the only state in the union that has not repealed Article 6 at this point.
Okay, thank you.
Yep. Used to use it years and years ago.
Yes.
As the sales of businesses, but don't anymore. Is there anyone else in the audience who wishes to speak to Senate Bill 65? If not, we will close all further public comment. And Senate Bill 65 is now on the breast of the committee. Any discussion among committee members? If there be none, the chair will entertain motions. We have a motion due pass by committee substitute. And any second on the motion? We have a second. Any discussion to the motion? Any further amendments? There being none, the chair will call the main question, which is due pass Senate Bill 65, LC 296614 ERS. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you too, Senator. No doubt. No doubt. Sandy, we have any judges with us today? Glad to have you, Judge. Always pleased to see our judiciary here observing. Good to have you. Next we have is going to be, I'll take Senate Bill 135, which is Senator Bethel. There you are. I thought you'd come in. Please have a seat, and anyone with you or by yourself, all right?
Mr. Holloman, I think, may be here from the clerks. It's crowded, I think.
The door shut there right quick. There we are. I guess that door was open, a little noisy. We're going to take Senate Bill 135, LC 296623S.
Thank you, Mr. Chairman. And I have the addition that the subcommittee had before. I haven't received the 2-3, but I think I've got the changes marked. But if I miss one, I think we'll be able to catch it. Senate Bill 135. Thank you so much, Susie. Senate Bill 135 comes from our Superior Court clerks and has picked up Part 1 which is the sunset of our process servers
Right.
language, and I'm supportive of that. The bill itself fundamentally intends to do two things. One is to clarify the proper method for backing up records that are the responsibility of a clerk, and then to ensure that the clerk is, even if those are backed up off-site or in a remote position from the actual clerk's office, that they are still records that the clerk is responsible for, so that requests for those records would come through the clerk themselves. So if you look, the language of the bill, basically the page 2, lines 22 through 53, that is establishing the process for managing the records, and then the page 3, line 58 through 92, is the backup procedure. The backup. I will note for the members, this came at the request of the clerks, but it does now require, really for the first time, a two backup model, and that is a change. It is requested by the clerk. So one of those backups, by definition in this bill, would be remote. That would be at the authority, the clerk's authority, which is good best practices in data retention, so that if you had a fire or an accident, you have it at a separate location. But that is a change at their request.
All right.
Welcome questions or.
Thank you, sir. Any questions by members of the committee of the presenter? Yes, sir.
Senator Bethel, I apologize. I missed the first part of the explanation. I was distracted. So we're going to require for electronic backup, is in a way we don't now.
Well, what we're doing now, what we would be doing is saying that we would be clarifying the electronic backup procedure, but then requiring them to have a backup in two ways, meaning one that would be it could be on-site, it could be in the county's IT server, it could be AOC might house it, and then a second electronic backup that would be at the clerk's authority. So it's requiring, as opposed to, it used to say in at least one of two ways, now it will say in at least two ways, so that we'll have that digital record in two locations.
Of everything in the clerk's office.
Everything that the clerk is required to retain from a statutory standpoint. Yes, sir.
And obviously you've worked with the clerk's authority and the clerks of court people on this, and they're all good with it.
Yes, sir. I am carrying it at their request. This is the language they presented.
I got you. Okay. All right. Thank you.
Yes, sir.
All right. Any further inquiries by members of the committee of Senator Bethel? If not, anyone else wish to address the committee on Senate Bill 135? No one else? Then we will close all further public comment, and the bill is now in the breast of the committee. Discussions among committee members. Mr. Welch.
At the appropriate time, I have an amendment.
All right. No one have any further discussions. The chair will entertain a motion for Senate Bill 135. Motion is due pass. Do we have a second?
Second.
We have a second. Do we have discussions on the motion? Any amendments? Mr. Welch.
Yes, sir. On line 45, the word government, at the request of Chairman Jacobs, he would like to change that word to governmental. That would coincide with the use of governmental in line 32. When we describe the department, agency, authority, we refer to it in 32 as governmental, and he'd like to see that the same at line 45.
All right. Do we have a second to the motion? Any objection to the motion? No objection. We will consider that motion accepted. Do we have any further amendments? There being no further amendments, the chair will call the main question, which is a due pass of Senate Bill 135 as a committee substitute as amended. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Thank you, Mr. Chairman. I
Thank
believe
you.
Chairman Jacobs indicated this morning he would carry this bill.
Thank you so much.
Thank you, Mr. Chairman, members of the committee.
Appreciate that. Next we have is Senate Bill 138, and we have Coomer. Come on. Glad to have you here. And Mr. Bobby Cagle's with you. We're going to put you on these two chairs. We have two mics. Let you come over if you can to the two mics there, and we'll hopefully get the door shut in just a second. Commissioner, Director, glad to have you with us.
Thank you very much for having me.
Let me announce what we're going to be doing, Representative Coomer. This is a bill that has not been through subcommittee. I was concerned from a time standpoint that we were getting close to the end of the session. We had the bill moved from another committee to this committee, so we had a little oversight about it, since we had a couple of us have been directly involved with the Governor's Commission when that was being worked through. And so I wanted to have Director Cagle with you going through, talking about the bill and where you see there's a couple of things I believe Representative Oliver has brought to our attention that she has some questions or issues about. If you have questions or issues, we also want to discuss that, because I know there's some things that have been put in preparation of the bill for this committee that were happening just for the first time. But I hope it's something we can get cleared up. Great. And we'll let you go ahead, and whoever wants to speak first on the bill.
Go ahead. Thank you very much, Mr. Chairman, members of the committee. I'm going to walk through each one of the sections. This is a pretty lengthy bill and has a number of changes, and I'll try to call your attention to those as we arrive there. This bill is a result of the Child Welfare Reform Council and the recommendations made by that body. In Section 1, the first change to law codifies the Governor's executive action from 2014, which says that the DFACS director shall be appointed by the Governor and report directly to the Governor, serve at the pleasure of the Governor. You should note that this is a change, however, from the Senate version, which had a requirement that the DFACS director's appointment be approved by the Senate, and that has been removed in this substitute. Also in Section 1, there's a creation of a State DFACS Advisory Board consisting of 20 members appointed by the Governor. It goes on to list some requirements around this, including representatives from each of the 15 regions within the Division of Family and Children's Services. Also requires that 5 of these be state legislators or representatives, and then that you have categories of membership that will give us the best opportunity to have a variety of expertise to advise the DFACS director on the operation of the division. Section 2, this clarifies the purpose, powers, and duties of existing county-level DFACS boards in statute. It also ensures that members who serve on these county boards are experienced in various areas of child welfare and has suggested fields of membership there, including pediatric health care providers, school personnel, law enforcement, private providers. It does have a slight change in wording at the line that refers to foster parents. We have added former in front of foster parents. The reason for that change is because we want to avoid potential conflicts of interest, because this board will oversee some of the foster homes in those counties. In Section 3, this is a change in language from the Senate version. And what this does is gives a clarifying statement for the purposes of the county department and to also enumerate those purposes, strengthens the purpose statement for DFACS. Section 4 establishes a DFACS Regional Advisory Board in each region to bring information from the county level DFACS boards to the regional level to ensure improved communication between each county and the state and improve service delivery, as well as provide information to the DFACS director and the departmental leadership about the operation of those respective regions. Section 5 adds 3 definitions to 49.5-3 regarding children and youth services. All 3 of these definition changes are required for a later section that deals with federal law changes related to providing normalcy in foster care for foster children. The included changes are the definition of age or developmentally appropriate. The intention behind this is that the department should consider what is age and developmentally appropriate for a foster child, including things such as should overnights with friends be allowed, and at what age should those things take place. Also adds a definition for caregiver, And the most important part of this is it adds a definition for reasonable and prudent parent standard. Basically what it says is that a foster parent should be able to exercise reasonable discretion as they would with a child of their own, and it gives some more latitude for foster parents than what they have currently. In Section 6, this is codifying common law regarding voluntary placement agreements. This is the first of a series of changes that I will enumerate here that are required by the federal Title 4E language. Title 4E is our primary source of federal funding for foster care. It amounts to $108 million annually, and these are requirements that came to us from our federal agency, all ones that we agree with, however. Section 7 is a change required by federal law in order to ensure the agency doesn't lose additional federal funds. This one pertains to definitions, again, related to the abuse investigators, other matters that pertain to this. I think this is also the beginning of the section that defines a central child abuse neglect registry. The committee should note that this is a effort to clean up a prior piece of legislation which was found unconstitutional by the Georgia Supreme Court due to the fact that there was no due process opportunity for a person to have their name removed from this once being placed on.
And I'm going to let Ms. Oliver speak at length about that issue. You want to do it now? I was going to wait till she gets. I want to let you. I'm sorry.
Oh, okay.
My mistake.
I was.
I'll let you go ahead and present it. I'm going to come back to that, so Ms. Oliver can talk about that as a matter of her involvement.
Okay. It was pointed out. Thank you for the break there. It was pointed out during the break that I had skipped one section. I want to make sure that we get you information on that. That's at lines 437 through 445. It is an important provision that has been a matter of practice and policy, but not of state law, that requires that we provide those that are exiting foster care a series of documents including birth certificate, social security card, medical records, and educational records, as well as information about how to get health insurance if they don't already have that. Moving on to Section 8. This is, again, a federal requirement for Title 4E funding in the amount of $108 million. The statutory goal here that is stated is that no more than 25% of children remain in Title 4E foster care system for more than 24 months. This is a standard of practice that is widely accepted as being best practice throughout the United States, and it's one that we have met for many consecutive years, so it's not a burden upon the state. Section 9 is about legislative intent and language that would support bidirectional data sharing between state agencies in DFACS, to allow DFACS caseworkers to ascertain a complete picture of the services that needed to be provided to the child and to the family. This is essential to us being able to do a good job at protecting children, and I think it's one of the things that will help us make inroads on preventing child deaths. At the heart of many of the child deaths that I review is a lack of information that would have helped us make better decisions. In Section 10, this adds language that ensures child care providers have the appropriate access to records relating to children in their care, and this is pertaining primarily to foster children. It also requires us to make contact with the appropriate school personnel when a child in the school is being suspected of abuse or suspected to be abused or neglected. This is something that I changed by policy, but I think is very important for to be recognized in state law. It allows us to have a conversation with school authorities that see the child on a regular basis, that are the extra eyes and ears for us that prevent that child from being further harmed. Section 11, again, is dealing with the Child Abuse Registry with a start date of July 1st, 2016. This is a registry, again, that was previously found to be unconstitutional because it did not have a appeal provision. It will contain records of individuals who either have one of two things. The first is a substantiated case found by the department to have, by a preponderance of evidence, the likelihood that the offense occurred. The second is for those that are convicted of a child abuse offense under state law in one of our courts. It also provides for provision that the child abuser will receive timely notice from the division and that their name is being placed on the registry, and give them their appropriate appeal rights so that they can have the benefit of an appeal. Those appeals will go to the State Office of Administrative Hearings and then be subject to further appeal to to the next level of courts, which I think is the Superior Court. In Section 12, this is repealing a section that allows for the recommendations of the Child Welfare Reform Council. I'm sorry, I apologize. This repeals what was known as the Council for Welfare Administration. The council is now called the Georgia Professional Human Services Association, and this does not any longer need to be included in the code.
Statute, right?
Yes, that's a cleanup. Section 13 brings state law into compliance again with federal law. Section 14 is, again, one of those compliance issues. It expands the list of people that must be considered in a diligent search for relatives. So basically, this is requiring the department have a holistic search for relatives, including the parents of any half-sibling. So we're looking broadly for family that may be able to step in and provide care for the child in the event that the parents cannot or will not. Section 15 is a change in the definition of placement change. The statute here requires that the department provide notice to the court and to the parties in a foster care case anytime we change placements. There is a misunderstanding within a few courts around the state as to what placement change constitutes. So this clarifies that. It basically says that temporary stays in other homes, such as an overnight with a friend or a vacation with the foster family, does not constitute a placement change. In Section 16, this speaks to permanency planning, and permanency planning is the process through which we arrive at what the permanent plan for a child is. The permanent plans that are possible include reunification with the parent, adoption, guardianship, and under this change, placement with a fit and willing relative, as well as another planned permanent living arrangement. This is a catch-all term that allows us to provide for children who cannot fit into one of those other plans, but it also provides limiting language so that we don't automatically select that, because we know that that is not the best for children if we can at all avoid it. Section 17 assures that Family and Children's Services has exhausted all options prior to seeking a permanency plan of another planned permanent living arrangement. Section 18 allows DFACs to purchase placements without competitive bidding with the oversight of the DFACs director. And let me explain a little further on this. This basically pertains to the purchase of services for foster children, such as foster care placements. The competitive procurement requirements really are not needed here because essentially we are the largest consumer of the service in the state. The legislature basically sets the rates for this, and there's no real advantage to the state to engage in a competitive procurement process. It also allows for us to prevent unnecessarily disrupting a child's life by having to place them in another home just because a contract ran out.
Very
Now,
good. just to summarize a little bit, a number of these recommendations came out of the council,
They did.
and a number of them are really cleanups that have been brought about through your directorship and seeing things that need to be clarified, modernized, and changed if necessary.
That's correct.
And you worked with the governor's office, of course, getting all this put together. I know we have, I want to recognize Ms. Blank, Ms. Cynthia Blank, who is the chair of the Governor's Commission. Would you please stand up for us, Ms. Blank, so we can give you appropriate recognition and thanks for all the work that you have done. You've got some other members of your commission here. Are those other commission members present who, Darrell, I know you back there hiding. Come on, all. If you're standing, if you're here, and of course the people in the governor's office who work very closely with this whole program are also present. I want to express a public thank you to all of what was done by this group over the last year, really meeting at least monthly and then having subcommittees meeting even more often, putting together these provisions, but also a lot of technical things about the operation itself, which are not needed in legislation, but are policy changes for your department. We're real grateful for your leadership, Mr. Cagle. So thank you for coming in today. And I believe we got some people who may want to ask questions of you, Mr. Weldon.
Thank you, Mr. Chairman. Thank you, Commissioner Cagle. I know this has been quite an undertaking. I marked some language I want to ask you about. In Section 7 on page 13, on line 449, it says, and I think it's a reference to the OCGA section 49-5-12.2, and beginning on line 450 it says, and I quote, any foster parent, caregiver, or child welfare agency or other entity under contract with the Department of Human Services shall be immune from liability as a result of a caregiver's approval of the participation of a child who is in the custody of the department in an age or developmentally appropriate activity, so long as such caregiver acts in accordance with a reasonable and prudent parent standard. Is that right?
Yes, sir.
Can you just give me a background on why you put that language in here, or why the state's putting that language in here?
So this is actually a compliance language with the federal provisions of this bill. The thought behind this is that we want to promote children participating in developmentally appropriate activities, and right now that doesn't necessarily occur. We, for instance, want those who are interested in playing sports to play sports because we know that that is good for their development. Oftentimes, foster parents are reluctant to have, especially children participating in contact sports. That is something that we need to have regular discussions with the foster parents on, but we also want them to have an opportunity to make decisions that a parent would make in this place. We've basically vetted them for the appropriateness as being a parent. And so we want those kids to be able to participate in activities that would normally be expected for youth of their age. One of the examples that oftentimes is given by child care providers is pickup basketball. So if a kid wants to go down the street to play pickup basketball, some of the providers are reluctant to allow their foster parents to allow kids to do that because they're afraid they'll get hurt and that they will have some liability in that case. What this does is really give a clear statement that as long as they're exercising due caution under the reasonable and prudent parent standard, that they will be immune from those type of situations.
Well, this is language that's in compliance with federal guidelines?
That's correct.
Where did those guidelines come from? Where's the source of those guidelines?
The source of the guidelines, are you talking about in terms of federal law?
Yes.
I need to get you that. There was recently a law passed that pertained to all of these issues that are contained in this section as well as sections 12 forward. The requirements around this are that states that receive Title IV-E money, $108 million in this state, if you do not incorporate those into state law, then you're at risk of losing all federal funds for those purposes.
So how great is the risk if we don't give immunity to people who are taking care of these children? Because I saw a bill came through the Juvenile Justice Committee 2 years ago, and it said, you know, they wanted to make it a state secret if a child was abused while in the custody of juvenile justice. That didn't make it out of our committee.
Right.
But this kind of rings very familiar.
I would think, sort of, that this is a bit different. This is really a matter of being able to allow foster parents to exercise the same kind of discretion that a parent would exercise. And the thing that we know is there's a great deal of reluctance to do that right now because of the potential liabilities that are involved. We have not, as a department, not really encouraged that either, because I think the risk aversion for the department as well as for the foster parent ends up in a situation where kids can't really lead normal lives while they're in foster care, because we don't want to run the risk that they will be injured in something that a child in a family home otherwise wouldn't have to be concerned with.
If I could just ask a few more questions,
Yes,
Mr.
sir.
Chairman. Well, I guess I don't understand the concern about this, because if the standard for a foster parent, there's going to be concern, a heightened sense of concern, because the government, if you ask me, and if it would be someone who's well vetted about having a child that's been placed with them by the government, then, but the standard for their conduct shouldn't be any more than it should be for any other parent that has children. They have to provide food, clothing, shelter, emergency care, and they get them an education. That's what they have to provide, and I think that's a well established part of Georgia law, and I don't know why that wouldn't suffice for this right here. What this says is that we're giving immunity. It doesn't say we're giving them immunity. It says they shall be immune from liability as a result of a caregiver's approval of the participation of a child who is in the custody of the father.
Yeah, responsibility. I think, and I understand the purpose, but I believe what you've got, Mr. Weldon, with the parent is that there is no way that a child can sue the parent for damages. Now, that's a principle, common law, that carries over to this day. So my children cannot sue me for what I have had them do as parents, as a parent, for activities. It doesn't stay with going to now someone else's care as a third party, which would be a foster parent situation. And I think that's what the bill is attempting to do, is saying that same immunity that a true parent has would carry over to what would be someone now standing in that role for this foster child, unless, and that's the standard applied as far as this parental standard we talk about as prudent. What would a prudent person do in the same circumstances? But may I say, just from a time standpoint, if you will, perhaps bear with us and have a discussion with Mr. Cagle. I get to try it. Sorry about it. Mr. Cagle on that point after the committee, because that is something I want you to get clarity to.
Yes,
sir. Judge?
That was my question, was on that section.
All right. And over here we have Ms. Oliver.
Just very briefly, if we had the federal language, that'll probably help us. But I see it as giving the foster care parent the same standard as a parent would have, and not increasing the standard or lessening the standard. I remember being called by a foster care parent who had been told by a caseworker that she couldn't allow the foster care child to go with the family on the Bragg trip, the bicycle ride across Georgia. And that should be a prudent parent standard to decide whether or not a child was age appropriate to go on the Bragg trip, and that should not have been denied that foster care. It was an extra concern about liability that didn't ring true to me. But if we had the federal language that we're trying to
think we
comply
could
with, that
have
would help.
Working on it.
And we'll
Yes.
get that put. We're going to have a hearing only today on the bill. It's only going to be a hearing today. We're going to be looking at considering motions on Thursday because I think there's some cleanup language, Ms. Travis, that you're working on. Is that right?
Yes, sir.
Thank you. Ms. Oliver, I didn't mean to interrupt, but do you have anything further you want to speak on the bill?
Mr. Chairman, the only
Homer.
thing I would add in response to Mr. Weldon's concern is, and I think it may be, I don't want to overstate the obvious, but we're not giving immunity for any liability for anything that any of us would call gross negligence or placing the child in any undue harm or doing any specific abuse or harm to the child or putting the child in unnecessary danger. So to that extent, there's not immunity for that kind of activity like what we had in the Juvenile Justice Committee a few years ago, only for what we would expect a reasonably prudent parent to do.
Mr. Weldon.
Thank you, Mr. Chairman. I guess my response to that would be that the language in 450 says any foster parent, any caregiver, well, I'm changing it, says any foster parent, caregiver, or child welfare agency, that's an agency, which is substantially different from a caregiver or a parent. A caregiver or a parent is a person. That just, you can touch skin on them. And then it says or any other entity, and I think that's an inclusive or, and that's a particular concern to me. I think after the explanation, I understand and I appreciate the explanation, and that's compelling, I think. But the language is in these lines right here.
Let's look at it, work on it some next 2 days.
Thank you.
For the full committee to be reviewed.
Thank you, Mr. Chairman.
Ms. Oliver, you want to
Thank you.
address the questions that deal with the registry?
Thank you, Mr. Chairman. Beginning in Section 11, line 630, there is essentially the recreation of the Central Child Abuse Registry. And the purpose of this enactment is set forth in 685 on page 20. It's to identify and locate substantiated cases of child abuse and convicted child abusers, and to maintain and produce statistical data on substantiated cases. In the 90s, there was an effort to create a central child abuse registry, and the Georgia Supreme Court in State v. Jackson declared it unconstitutional. And I think it's helpful to discuss just briefly today why this analysis, a provision of a central child abuse registry is effective, will sustain any kind of examination, and to also be a little bit extra careful. And of course, Jill Travis has helped us with doing some fairly minor corrections. In 1990s, the initial child abuse registry created a central registry for both unconfirmed and confirmed child abuse cases. This registry only asserts a registry for the purpose of convicted individuals in the criminal court system of child abuse, molestation cases, and substantiated cases of child abuse. In the earlier registry, we did not at that time have the Office of State Hearings and Appeals. And under this time, given the sophistication of the Office of State Hearings and Appeals, you're going to get, under the Administrative Procedures Act, a more substantial review. The person who is put on the registry based on either a conviction or a substantiated case of child abuse is entitled to an administrative review hearing, which of course then goes to, under the APA, Superior Court review, to determine whether the placement is supported in the criminal case by credible evidence, and in the substantiated case of a child abuser by defects investigation, preponderance of evidence. That standard of proof was not set forth in any clear way in the earlier child abuse registry. Mr. Chairman, the specificity of the way in which a minor who may be alleged over 13 to be a child abuser, him or herself, also creates additional legal protections for that child, which was absent in the earlier review. So the narrowing of the narrowing of the definition of anybody who would be put on the child abuse registry, the clarification of the standard of evidence, the protection, provision of legal counsel or assistance to children who are involved in such a proceeding, all places this legislative effort in a basis where I feel like the Supreme Court would give it a more favorable response.
I know you've had a strong interest in this through the process we've been going through with Senate Bill 138. I appreciate your working on that area of it too very much, Ms. Oliver. We have a couple of the people who want to speak to the bill. If we have no further questions of the presenter, I'm going to ask that we have David Tatum. Mr. Tatum, always glad to see you.
Sir?
You want to stand or you want to?
I'll be happy to do it from here if y'all can hear me.
We can hear you.
Children's Health Care of Atlanta is the entity formed by the merger of Eggleston and Scottish Rite back in 1998. And we operate those two hospitals as well as the Hughes Spalding system. We also house the Stephanie Blank Center for Safe and Healthy Children, a child protection agency. And we have 3 of the busiest emergency rooms in the state, actually in the country. And last year we saw 1,900 children came through our system that were either sexually or physically abused. The math on that is rather sad. That's an average of about 5 children per calendar day. We rise in support of this bill because reinvigorating the child abuse registry and giving DFAC some of the other tools they need to address this is something we support. I'd be happy to answer any questions.
Any questions of Mr. Tatum? We appreciate you being here and work your hospital does too very much.
If I didn't compliment Representative Bruce on his trendy and fashionable neckwear today.
Thank you very much. Okay. And we also have Wayne Drummond. Mr. Drummond, thank you.
Thank you.
Come forward, please.
I'll be happy to stand as well.
All right.
I have a document I'd like to pass along to you. Thank you so much, Mr. Chair and members of the committee. My name is Wayne Drummond. I'm the Executive Director of the Georgia Professional Human Services Association, and today I'm representing also one of our affiliate members, the Georgia Association of DFAC Boards. We are very excited about the improvements in child welfare, and I'm so grateful to the governor for establishing the council, grateful to the council for exceptional work, grateful to both chambers for passing the budget, done a lot of improvements, and I believe that this particular bill is one of the linchpins for sustaining progress over time, and we're just really grateful for that opportunity. Pat Swan is the president of the DFAC Board Association for many years. They have been primary training people for the county DFAC board members, and she could not be here today because their annual training conference, the semi-annual training conference is today. They wanted to propose for your consideration a slight change in the law, but the basic configuration of county boards are that they have always been lay citizens appointed under the discretion of the county appointing authority, and it could be a citizen from any walk of life. The intent of the legislation is to establish natural partners, school system, mental health professionals, public health folks, and other people to really help focus the planning and the safety of children. The Board Association supports that. However, they would be more comfortable if there could be a bit of lead time in the implementation of the bill, both as it impacts the leadership of the Board Association, consistent with many current members of county boards and board associations and transition law. And so they effectively want to add a sentence in front of the list of the categories to simply give a little bit of time-limited grandfathering that would allow the governing authority may, in its discretion, reappoint current board members who are not in the following categories to another term until July the 1st of 2017. This would help to ease the transition from the current configuration of county boards to the new configuration.
You know, they've got 5-year terms as it currently exists.
Yes.
So what would that add to it as far as making 2017 a time frame?
It would not, if they're reappointed, it would be for another 5-year term. It would only be for those that the county chose to reappoint. I think the concern of the Board Association is that they would lose half of their executive leadership in the next couple of years. And this is just a way to try to ease that transition and also to use it in 159 counties. There was a second item they wanted to ask for consideration on, and that was adding to the categories an asset in the area of food insecurity. The way the categories are configured is we have somebody, for instance, a community food bank who is intimately involved with the operations of family and food resources, both for child welfare supports and for the other programs operated by the department. That could be a valuable addition to the so those are the two suggestions that we need to make.
All right. Thank you, Mr. Drummond. Any questions by members of the committee? If not, we appreciate you being with us today. Does anyone else wish to address the committee on Senate Bill 138 today? As I mentioned, we're still having a few minor tweaks of it being made, and what we'll do is not have a consideration of the bill in fact today, but that'll be done on Thursday at the regular meeting of the committee. So with that, we'll close all further presentations on Senate Bill 138 at this time.
Thank you.
Thank you.
Will be excused.
You may.
Thank you.
Certainly can. We will have, is there anything else to come before the full committee at this time? If not, we're going to adjourn.